and welcome to a newsflash episode of Unpacking the Case, the podcast by Davitt Jones Bold, the real estate law specialists. As always, I'm joined by our head of legal training, Richard Snape. Hello, Richard.
Hello, Lizzie, and what have you been up to lately?
I have been busy for a Monday, thank you. We've had a webinar already to start the week. And yes, and we're here for a long-awaited discussion about the draft Commonhold and Leasehold Reform Bill, which came out on the 27th of Jan and has been the topic of lots of conversation in the industry. So do you want to just start by giving everybody the background? What is Commonhold? Why do we need it?
Oh, I'm sure. Why do we need it? The first thing is it's a draft bill. It's for consultation. The actual consultation ends on April the 24th this year. So you've still got time, Lizzie, to put your bit in. I'll tell you the real background. I'll go back to sort of landlord days. It's not just about flats, but it's primarily designed to be, in relation to flats, if and when it comes in, they're saying before the next election, it'll be unlawful to create new leasehold flats of dwellings or flats of more than 21 years duration, with a few exceptions like shared ownerships and build to rent and equity release and Islamic mortgages, which work on a sale and leaseback, community housing as well. And it all goes back to 1885 in a Court of Appeal case called Austerbury and Oldham Corporation, which I think was one of our top cases that we recorded years back. Do you remember that?
I do, yes.
Are they still available?
Yes, we can link to it in the description for people.
Yeah. So anyway, it's Austerbury, the most disastrous case in the whole of English and Welsh property law. It said that in freehold land, you can enforce restrictive covenants. They're property rights, so they can bind, subject to things like registration, but we won't go down that route. They can bind third parties. Well, positive covenants, you can't, and maintenance is a positive covenant. And that's caused problems ever since. If it's a leasehold, on the other hand, if the lease was created prior to the Landlord and Tenant Covenants Act coming into force on January the 1st, 1996, the covenants will be binding under something called Spencer's case from 1583, which we also did one of our top property cases. If they touch and concern the land, the covenants will pass with the land and bind third parties. Since 1996, they do under Section 3 of the Landlord and Tenant Covenants Act, unless they're made personal when they're created. And it's absolutely essential you have maintenance in blocks of flats. And you need common parts to be maintained, and you need structure and exterior and dividing walls and so on, the roof to be maintained, which is why the vast majority of flats in this country have been created through leaseholds, long leaseholds. But they've received a lot of flack over the last few years, primarily because of developers imposing escalating ground rents. Nowadays, since the Leasehold Reform Ground Rent Act came in the end of June 2022, then you can only create a peppercorn unless it's an exception, like a shared ownership and equity release again. But governments have thought to themselves, let's do something about it. And what they want to do is resurrect Commonhold, which actually came into force in September the 27th, 2004. I was doing courses on Commonhold when it was brand new, when I was just a child lecturer with darker hair. But it never took off. I think last I saw, there's around about just under 200 Commonhold units and less than 20 developments for various reasons. Shall I explain Commonhold in a nutshell?
Yes, please do.
Well, what you do is you set up a Commonhold association, and the Commonhold association will have the freehold. It's not a different type of estate in land, as people say. It's freehold. They'll have the freehold of the common parts. You say it doesn't have to be flats. It could be other things besides. It could be commercial, could be houses, could be a mixture. And they will, well, all the various unit holders will have the freehold to an individual unit, so you could have a freehold flat. And all the unit holders will become members of the Commonhold Association. Limited by guarantee, currently with a £1 guarantee. And they'll all agree something called a Commonhold community statement. There'll be a memo and articles of association and so on. And they'll all agree a Commonhold community statement, which dictates the various terms and obligations and rights between the various parties to the Commonhold. And periodically, you'll have to pay a Commonhold assessment. You can have local rules and the likes that deal with the specific premises, but periodically you'll pay a Commonhold assessment to pay for things like repairs, maintenance, gardening if needs be, and so on, improving the premises. And that's the idea. That's Commonhold. And it sounds remarkably like a residence management company because that's basically what it is.
Mm-hmm.
You're in a residence management company, aren't you?
I am, indeed. Yes.
They basically, you got a 999-year lease of your place in Bristol.
Yep, I do.
There's not too much difference between a 999-year lease and a freehold. And basically, the Commonhold Association is the equivalent of a residence management company. The Commonhold assessment is the equivalent of a service charge, and the community statement is the equivalent of a lease.
Yeah.
That's the basic idea. So there'll be no ground rents or anything like this, but that's the basic idea.
Okay, so with the new bill or draft bill, what's going to change?
Well, it never took off for many reasons. Until recently, mortgage companies didn't. Most mortgage companies would say no to it. Most say yes now because there's obviously been pressure from government. And insurers don't like it for various reasons either. And it had various issues. One is that there was no ability to effect forfeiture. Therefore, there was inadequate threats for the people who didn't pay the community statements. So the community assessments, Commonhold assessments. And also the statutory control under the 85 Landlord and Tenant Act of service charges in leasehold dwellings didn't apply to Commonhold. You couldn't question the reasonableness or whether work was reasonably incurred. There was no need to consult and so on. And I think above all, probably, together with the mortgagees and insurers not liking it, you can't create a residential lease in a Commonhold of more than 7 years duration. And if you can't create residential leases, you can't have shared ownerships and you can't have equity release and this kind of thing. And certainly a few years back, you probably wouldn't get, you wouldn't get planning permission unless you build an affordable housing. And then, historically, that means shared ownerships. You can't have shared ownerships in Commonhold. All the developments are quite small so far. But it's been talked about some time. The governments and parliaments got this idea that leases are feudal. They're no more feudal than freehold, quite honestly. They're fixed maximum duration as opposed to freehold being of uncertain. Fixed maximum duration could be a 10,000-year lease, or like you've got a 999-year lease. Freehold could be a life interest, which lasts for your life. Not normal, but it could be. So there were sort of various issues, but it was the previous government we're talking about sort of amending. But then in the King's speech after the last election in July of 2024, it was the King's speech anyway, the government announced that they were going to go ahead and publish this draft Commonhold and Leasehold Reform Bill. It was meant to be published last year, and it kept being put back and put back. And just before Christmas, they announced that due to unforeseen circumstances, it won't be published in 2025. But then it was published on, as we mentioned, January the 27th this year, and it's been talked about much. And it makes a lot of changes. It's not just about Commonhold, but it makes a lot of changes. Most notably, you will be able to create leases of more than 7 years in relation to shared ownerships and equity release and, Islamic mortgages and the likes in Commonhold. And also, at the moment, you have to have buildings insurance, but in the future, you'll have to also have public liability insurance. And unlike the moment, in the future, there'll be a mandatory reserve fund to deal with emergencies, like the ability to create fixed or floating charges to pay for such things, which isn't there at the moment. Also, significantly, it won't be a sort of one size fits all. You can have sections, different parts of the development, and the big common holds in particular having different assessments and the likes. Because otherwise, it doesn't make sense for houses to have the same assessment as flats, to have the same assessment as commercial properties. And although they're not going to have forfeiture, they're going to get rid of forfeiture and leasehold dwellings generally in the same bill. Then you'll be able to go to court if somebody doesn't pay the assessment, and the courts will have a wide discretion. Ultimately, they could force sale of the property. And I say there are quite a few other things besides. No event fees in the event of you selling or whatever, apart from in retirement homes. And it's going to be a complete and utter rewrite. And as I say, sometime, if we're to be believed, before the next election, with those exceptions, you could be fined if you try and create a leasehold flat. There's also provisions already in the Leasehold and Freehold Reform Act which ban new leasehold houses. But that just seems to be going nowhere at the moment, with a few exceptions, again, like shared ownerships. And also, at the moment, if you want to convert your leasehold block into commonhold, you've got to get 100% agreement of all the parties, the freeholder, all the mortgage companies involved. They are going to only require a 50% agreement of the various parties, they say, in the future. You still need the mortgagee and the freeholder's consent, but only 50% of the various unit holders. And if people don't want to go ahead with having a common hold, they're happy with their leases, they can keep their leases, but when they come to sell, they'll have to sell it common hold, which the mind boggles a little bit on. So that's the basic idea. That's the common hold side of it. The draft bill, there's a lot of other things besides, but that's the common hold side of things.
So what are your conclusions, Richard? What do you think about all of this?
Well, it's like any management company, Lizzie. You need to have somebody managing it. You often, anybody who's got to deal with residents management companies. The first property I ever bought was a masonette in Westbury Park in Bristol.
Very nice.
On a long lease.
Westbury Park's very nice.
Well, that's just me, isn't it? But even though they are the managing agents, they're obviously going to get rid of them, and they're trying to persuade somebody to spend 20 minutes of their year just agreeing the accounts and confirmation statement was nigh on impossible. It would have fallen to bits. I left I left various reasons, but that one was one of them. And that's just for sort of 5 flats in a townhouse conversion. You're not going to be able to cope with the management if you've got 50 flats in a mixed-use development. And I would not even dream of becoming a director of a Commonhold Association if it was a higher risk building under the Building Safety Act. It's got at least 2 residential units, 18 metres or more in height, or 11 or more stories, because the Commonhold Association will be the accountable person and have quite stringent criminal offences attached. That's made clear in Section 72 of the Building Safety Act. They will have quite stringent criminal offences for non-compliance, and they're not going to be able to comply with the higher risk buildings regime unless they use somebody to help them. And I'll tell you my tale and finish off with. I do know people who've done common hold conveyancing. They say at least it's standardised. It's not difficult. But this is my other concern. I remember years back when it was brand new, doing a course in Bournemouth and about common hold, and the solicitor there telling me how he was called to talk to the members of an exclusive retirement development in Christchurch. Would you like to convert your leases, your leasehold block into common hold, because that way you can avoid the social stigma attached to being a leaseholder. You're shunned in the streets of Christchurch. People just walk over to the other side of the road. And he was explaining common hold, and after a couple of minutes, an irate woman stood up and said, "Mr. Smith, you're talking to the members of an exclusive Christchurch retirement development. Are you really suggesting that people like ourselves would ever wish to become common?" And that's the other problem. If they'd have called it exclusive hold, we'd have it everywhere by now.
It's all about marketing, Richard, isn't it?
Yeah. It's why agents call leasehold management companies share of the freehold, to hide the word leasehold. Do you know what they should do, Lizzie? If you wanted to, it's not just about flats and blocks of flats and so on. It's
Mm.
about maintenance of private roads and the likes. We have to have state rent charges or deeds of covenant and restrictions makes life a lot more difficult. And it's all because of the case we started off with, Ousterbury and Oldham Corporation. And if they wanted to do something useful in Parliament and government, they'd just reverse that. They'd have some provisions. You'd still need management, but you'd have some provision whereby restrictive and positive covenants can be enforceable against third parties in freehold land. And that's my solution. That's what I'm standing for Parliament on.
Richard's manifesto.
That's my manifesto.
Well, thank you very much, Richard.
Thank you.
Thank you very much, Richard, and thank you to everybody for listening. We'll see you again in our next episode.